Hello, everyone. Welcome to today's edition of the Live Employment Law Q&A by employmentlawyer.ca. My name is Teilen Celentano, and I'm an associate and employment lawyer with Samfiru, Tumarkin, LLP, and I work out of our Toronto office. As always, if you have any questions related to your employment law questions, please feel free to ask them directly, and I'll do my best to answer them live. You can ask your questions through Facebook, LinkedIn, X, Twitter, YouTube, and I'll answer them. You can also go to our website, employmentlawyer.ca, email us at help@employmentlawyer.ca, or give us a call at 1-855-821-5900. So I've got two stories I'd like to start with talking about today. The first is the recent news that came out of the US that GM was raising the bar, was changing their compensation structure based on employee performance in a new rating system. The gist of the story is that through an internal memo, GM announced that they were going to be rewarding the top 5% of their staff with 150% bonuses. So bonuses that far exceed what employees previously earned. And the reason they're doing that is because they're trying to compete with the electronic vehicle manufacturers like Tesla. Tesla, who offers huge stock compensation as part of their remuneration package. GM has been losing a lot of talent, has had a tough time keeping up. So the question now is that allowed? Obviously, this happened in the US, and based on the articles I read, it appears to only be applying to American workers. But if that happened in Canada, is that allowed? What are employee rights in situations like that? So the metrics they're using, the performance metrics they're using, are going to really depend on whether or not it's allowed. One of the things that in Ontario is most employees in the province are protected by both the Employment Standards Act and the Ontario Human Rights Code. So under the Ontario Human Rights Code, you're prohibited from being discriminated against in employment. A disability can take a number of different forms. It can be disability, right? So you have a physical limitation as a result of a physical disability. It can also be age, gender, and can also be family status, right? So if people are unable to meet those targets because maybe they're not able to work enough hours because they have to go home and take care of their kids, or maybe they're unable to lift enough things, or they're unable to be as productive with their hands because of a physical limitation, or maybe they're just older so can't move as fast as some of the younger people. If the end result is that due to the certain protected reasons, they can't meet those targets and are therefore being deprived and paid less because of the protected ground, then there's a chance that this policy could breach the Ontario Human Rights Code. The second thing to mention I'd like to talk about today is the layoffs happening with Intel. So Intel, obviously a big computer tech provider, they've announced that they're cutting thousands of jobs in order to help fund a rebound strategy, market repositioning. And whenever this happens, it's unfortunately been happening more and more recently. There's a bunch of things, a bunch of traps employees can fall into. When there are mass layoffs, so layoffs of multiple people, large groups of people, employers have enhanced obligations under the Employment Standards Act to pay out severance. It's more than just your minimums. In addition to that, employers will often present employees with a severance package, which they say far exceeds what they're entitled to. Now, it may exceed what they're entitled to under the ESA, but it doesn't exceed what that employee would be entitled to under the common law. Under the common law, our courts look at a number of factors to try to ascertain how much severance someone is entitled to. The big things they look at are age, length of service, and availability of similar employment. Those are the three big things. Our courts will look at those things and try to ascertain how long do we think it will take that person to find a new job. Oftentimes, those periods are measured in months and can be as much as 26 to 30 months. There's been a couple of cases that have gone, stretched the maximum to 30. So the maximum can be that high, right? It's generally the max is 24, but the ESA provides for a lot less. The maximum under the ESA is only 34 weeks. So companies, when they have these mass layoffs, will oftentimes make a settlement offer, a severance offer that they say is huge, that they say is very generous, when in reality, it's not. So it's important that whenever you're let go, whether or not you're offered a severance package, that you reach out to us at employmentlawyer.ca, book time to speak with one of our legal reps. Our legal reps will be able to look at your situation on a case-by-case basis. How many people were let go? How long were you there? What was your salary? What does the job market look like for you? And then after speaking with you, be able to provide actual real legal advice on what you'd be entitled to if we went to court, and how the offer, or whether the offer that the company's made is good or bad. Now, it does sometimes happen, albeit rare, but it is always refreshing when an employee is offered a good package. But that is exceedingly rare. More often than not, the company is trying to get away with paying pennies on the dollar, and avoiding a huge liability. And if you sign that offer, if you sign that severance offer before speaking with a lawyer, we're really limited in ways we can help you to get more. So really important to speak with one of us and reach out to us before signing anything. Our first question today on YouTube is from Avery. I was recently sent home from work because my employer said that I was not needed for the day. My employer required to pay me for anything for that day because they didn't call me to cancel and waited for me to show for my regular scheduled shift. Yes. So you do have to get paid, but you don't have to get paid for the whole day. Under the Employment Standards Act, there's a 3-hour rule. So you have to get paid for 3 hours of work. So if you showed up to work, they sent you home because they didn't need you, then they still have to pay you for at least 3 hours. So yes, Avery, they do have to pay you for at least 3 hours, given that you showed up to work. Now, in saying that, I'm assuming you're an hourly employee. I'm assuming you're an hourly employee who works in a regular shift as is. If you're a salary employee, it's going to be different. If you work a set shift, it could be different too. So if it's just a one-off, they do have to pay you the 3 hours. And if it doesn't happen again, then it would probably doesn't make sense to call us. But if this is something that's regularly happening, it may make sense to email us at help@employmentlawyer.ca, where one of our lawyers will be able to talk to you and really get to know the situation a little better. But I do think, in your case, you are entitled to those 3 hours pay. So absolutely talk to your employer about it first. Say, I showed up to work. I was here. I'm entitled to at least 3 hours pay, and see what happens. Ultimately, if they don't do it, you can also pursue it, getting that pay through the Ministry of Labor. Another question on YouTube from Francine. Does the employer need to give an employee what accusations are against them during a workplace investigation? My employer is saying they received complaints, but have not given any specific details as to what the accusations are. So Francine, this is something we come across a lot. So an employee is under an investigation. They don't know why, they don't know what it's about, and the employer isn't giving them an opportunity to respond. That's not fair. That's not right, and our courts have recognized that. So when these companies are performing their investigations, they have to give their employees a chance to respond to the allegations made against them. So what happened, why did it happen, this, that, the third. And then if at the end of the workplace investigation, the company determines that employment is no longer reasonable, you can no longer remain employed, then they may try to terminate your employment for cause, or for just cause, and terminate you without paying you any severance. Now, the bar for just cause is incredibly high in Ontario. Our courts have called it the capital punishment of employment law. And just like capital punishment, even though we don't have it here, but in the United States and some states, capital punishment is reserved for the most heinous of crimes. Termination for just cause is reserved for the most heinous instances of workplace misconduct. And one of the things our courts have said is that when companies go through this process, not only do they have to be right in that the alleged misconduct is happened and is proven, that it is sufficient enough to warrant a termination for just cause, but we're also able to look at the investigation itself. And what our courts have said is that employees have a right to respond. They have a right to know what the allegations are made up or what allegations are being levied against them, and to defend themselves. And then also that obligation that the employee be faced with the allegations is heightened the longer the employee has been there. So especially if you're a long service employee, Francine, and you've been there for years and years, then they do really need to tell you what the allegations are, give you an opportunity to respond, to give your side of the story. Ultimately, if the company fails to do that and they decide to terminate you for just cause, doesn't mean you're out of options. We have a ton of clients who come in, say, I was fired for cause. What do I do? They gave me nothing. You don't, as employees and as employment lawyers, we don't have to accept that. We can challenge it. So we can sue the company and say, no, you didn't have just cause, and we instead want a full severance package, which again, depending on the factors, can be as much as 24 to 30 months pay. So in your case, Francine, if they fire you without an alleged cause, it doesn't mean they're right. We get to sue them. And oftentimes, once lawyers get involved, companies do kind of click in and realize that it probably wasn't cause. But unfortunately, that's not always the case. So to put a bow on it, yes, they should. They should be giving you details of the accusations or the allegations made against you, and giving you a real opportunity to respond, and they should be carefully considering that response. If the company fails to do so and fires you anyway, there's unfortunately nothing we can do to have you reinstated. A judge would never award for a provincially regulated employee. A judge would never award that employee be reinstated, but instead what we get is a severance package. So I think one thing that's important as this investigation is going on, Francine, is that you document it as well. Request the allegations, request the accusations, put it in an email, and making sure you're keeping a copy of that email so that in the event that you do need to reach out to us and you do need to commence formal litigation, then you have that, that paperwork, that paper trail where you're asking for an opportunity to respond to the allegations, you're asking for the details, you're asking for this, and you're asking for that. The next question on YouTube from Corey. Can an employer recover lawyer costs in a civil litigation case against an employer? So yes, they can, and it's not just limited to employment case. It's applies to every area of law. So in Ontario, we operate on a loser pays system. So whenever you go to court and lose, you have to pay a portion of the other side's legal fees. It's very rarely 100%, very small, very specific circumstances, but generally you have to pay a portion of the other side's legal fees, depending on how long the litigation took, depending on how much the case was worth. It could be anywhere from 60 to 50 to 60 to 80% of the other side's legal fees. And that's what the loser pays to the winner. So there will always be a cost borne by both sides, right? You don't just get the lawyers for free, but if you lose a lawsuit, then you have to pay a portion of the other side's legal fees. The second way it can happen is in a settlement. So oftentimes, 99.5% of cases settle. That's, again, not just employment law. That's almost every area of law. Cases just settle because it avoids risk and it saves time and it saves money. So when those settlements happen, what oftentimes happens is that the company, in my practice, the company will make a contribution to the employee's legal fees. It's not in the range of 60%, unfortunately. It's not, as much as going to court, but the company will still make an additional contribution to the employee's legal fees in order to help defray some of that cost. So if the severance package is 12 months pay, they might throw in an extra $5,000 as a contribution to the employee's legal fees. That is one of the things is with all settlements, it's something that has to be agreed to. Ultimately, you could go to court and have a judge award something, have a judge award costs. But whenever you're settling, whenever you're negotiating, it's not something that is ordered. So it's something that has to come to with both parties. So if a case does settle, we can't, obviously can't guarantee that a company would agree to it. But to answer your question bluntly, Corey, yes, you can recover some of the lawyer's fees, but not all of them. And that's true whether or not it's a settlement or whether or not it is a judgment in court. A question on YouTube from Sir. A youth worker posted pics of minors on social media. Does this violate PIPEDA, and what are the penalties? Sir, I'm unfortunately not familiar with PIPEDA, so I'm not going to be able to answer that one. We don't really deal with that on a day-to-day basis, so unfortunately won't be able to help you out on that one, sir. Sherry. Is it legal for an employer to put a clause in an employment agreement that you owe them $2,000 in liquidated damages if you resign before 12 months? They don't provide any equipment, training, or anything else that is tangible to that cost. So as with all contracts, if it's something you agree to, it's something that could be enforced. So think twice about signing before you do it. There are always ways to get around contracts. There's always arguments we can make that a contract is unfair, it's unconscionable, or it's unenforceable because of this or because of that. But signing a contract does mean something. And just because we have the arguments available to us doesn't mean we'll always be successful, and we can never guarantee success. So if they could justify the liquidated damages claim, maybe it was the onboarding costs, maybe it was a cost they paid to the recruiter who hired you, maybe it was something else. They could justify it. There's a chance it could be held up in court. Now, of course, they would have to sue you for it, and they would have to go through a whole rigmarole in order to recover it. But if you're uncomfortable with that, and it's something you obviously are, if you've already identified it, Sherry, then don't sign it. Right? Say that it's unfair. Make sure that you get that in writing. Whether it's that the liquidated damages claim, or even sometimes relocation expenses. We've had cases where there was a relocation expense that was paid. Relocation expenses were paid to employees who, if you quit within the first year, 24 months, 36 months, you have to pay back a portion of it. And then they were forced to resign due to certain circumstances. They were then pursued for hundreds of thousands of dollars. So those clauses can be enforced. So if you're uncomfortable with it, if you don't think it's fair, don't sign the contract. I think it's the most important thing. Again, can we get around it? Potentially. But whether or not we could get around it is really secondary to whether or not you signed it, right? So employees, it's hard, employees don't really understand that, they do have less leverage in their negotiation of their contract, but they have the most leverage in negotiation after the companies pick them to be hired and offer them the contract. I'm not saying you have all the leverage in the world, nor am I saying that you can ask for whatever you want. But what I am saying is that that is a situation which you'll have the most leverage, and you may be able to get that removed from the contract. So yes, they can pursue you for that. It would likely cost them more than $2,000 to do so, but they could. So if you don't feel comfortable signing it, if you don't feel comfortable having to live with that, don't sign it. Ash MK, can my employer push me into a lower role because it would work better for my accommodation needs after being off on STD? So Ash, I'm not sure what you mean by a lower role. So whenever someone comes back from a medical leave, whether or not they receive disability benefits is kind of immaterial. Whenever somebody comes back and they need to be accommodated, the employer has an obligation to accommodate them. Now, accommodation can take a number of different forms, and it depends always on the workplace, the nature of the needed accommodations, and the ability for the company to do it. So, by a lower role, I'm not really sure what you mean. If you're going from a manager to a supervisor, as an example, or from a supervisor to just a rank and file non-managerial position, there may be legitimate business reasons for that. There could be, they may need a manager on more time, and you need to do a gradual return to work, which you won't be able to accommodate. Maybe managers are expected to lift more heavy things, and you have a physical disability that you can't do. Maybe it is a mental health disability that you can't, that you need, to be a gradual return to work, gradual ramp up of the stress and worry associated with work. So you may need, a non-managerial position to start, maybe what you need. So it really depends on the nature of your disability, Ash, and the company's workplace and your old job and the new job. It's a very case-by-case analysis. And I think in your case, would be advisable for you to reach out to us, employmentlawyer.ca, email us at help@employmentlawyer.ca, so that we can talk to you about it. Because whenever we're dealing with accommodation, it can really get into a tricky, a bit of a minefield. I think the short of it is, if there is a legitimate reason that to accommodate you, putting you in this lower role would be better for them or better for you, then they can. But it's important that they're still paying you your regular rate of pay, and that you're still, that job is still there for you. Your old job is still there for you when you're done being accommodated, if it's one of those temporary accommodations. One of the things that the Employment Standards Act says is that whenever someone goes off on a medical leave, when it's done, when they're ready to come back to work, they have a right to be returned to the same job if it exists, or if not, to a comparable one. The big thing is they have the right. It's not an option on the company. It's not a suggestion. It's not, this is ideal. It's employers must reinstate the employees to the position they had before they left. Unfortunately, we see companies violate this a lot when it comes to people who go off on a parental leave, whether mother or father. When they bring a child into this bring a child into this world, or they adopt a child, they take some time off to be with the child. It's been happening forever, and hopefully will continue to happen. And when that parent is taking 6, 8, 12 months off, the employers, understandably, are forced to bring someone in to that position in order to cover them. And a year later, when the employee comes back, the employer has realized, well, we like the person we hired, the temporary person, more than the permanent person. And then they don't want to bring that person back. And then they can do a bunch of insidious things in order to try and get this person to quit, to fire them, or sometimes just to straight up demote them. And when a company does that, when a company fails to return you to the same position, so long as it still exists, or if it doesn't exist and you try to return you to a lower paying job, a less prestigious job, a completely different job, you don't always have an obligation to accept it. Now, it's important not to reject a job, not to resign before speaking with a lawyer, because again, it is a case-by-case analysis. But when you're coming back from a leave and your employer is refusing to bring you back to the job that you had because, we like the person we hired to replace you more, that is not only a breach of the Employment Standards Act, that is not only a breach of the Ontario Human Rights Code, but it's also a constructive dismissal, and it is also bad faith. And all of those things entitle you to damages, entitle you to a severance package. So whenever you're coming back from medical leave, unless your employer is giving you your old job back, following your doctor's recommendations to a T, and just bending over backwards, if they're giving you any kind of pushback, it's a good idea to reach out to us at employmentlawyer.ca if you have any concerns. The next question is from Rochelle on YouTube. Rochelle asks, my company just merged with another company, and that other company wants us to sign a job offer. My hours of work are changing, and so is my job description. They gave us a deadline to sign a new contract. If we don't, we will be considered to be terminated in the past 35 years. What are my options? So, Rochelle, you have a few options. So whenever a company is purchased by whenever a company is purchased by another company, what your rights are, what your entitlement are, depends on the nature of the transaction. Whether or not it was a share purchase or an asset purchase is always very important. So in your case, obviously, without knowing that, if you're being asked to sign a new contract kind of during this transition, do not sign it until you speak with a lawyer. Well, a new employment contract can sneak a number of different things into an agreement that limit your entitlements in the event that you're let go. So if you're let go, a contract, if it's enforceable, can limit your entitlements to only those under the Employment Standards Act, rather than what you would otherwise be entitled to under the common law. The reason that's so important is, as I mentioned earlier today, the ESA, your entitlements maxed out at about 34 weeks. Under the common law, it can be 24, 30 months. So much different entitlements, vastly different sums of money. And it's really important that before you sign that contract, you speak with one of our lawyers to review it. That way we can explain to you what it means, what you're giving up, what you're signing away. And then ultimately, if after speaking with a lawyer, you decide not to sign that contract, then you may still be entitled to severance. Someone who's been with the company for 35 years, you would be entitled to a pretty hefty severance package. Again, other things need to get considered: your age, the availability of similar employment, the nature of your job, your rate of pay, but you would be entitled to a very fair severance package, a very large severance package. So don't sign that job offer before speaking to us. We review contracts, and we also can pursue employers for enhanced severance packages. So in your case, what are your options? Your best option, your best course of action right now, Rochelle, is to reach out to us so that you can set up a time to speak with one of our lawyers and have your contract reviewed by someone who knows what they're looking at. Excuse me. A question from Paul on Facebook. My current start time is 6 a.m. and finish at 2:30. I discussed this with my manager a few years back, as I must pick up my son from school. They're now pushing hard for me to start and end later. Please advise if I have any legal grounds to refuse a later start time. Could they fire me with cause and then avoid giving me severance? So a bunch of things to unpack there, Paul. And this kind of touched on a couple things I've talked about today. So it's a nice kind of way, as we're coming up to the end of the time, to really summarize things. So your start time of 6 a.m. to 2:30 p.m. You requested to pick up your son from school. That, even though you probably didn't realize it at the time, was you requesting accommodation on the grounds of family status, right? So your responsibility to your son as a father was to leave work by 2:30 so you could grab your kid from school. That is a family care obligation that is protected by the Ontario Human Rights Code. The company, even though maybe it didn't feel like they did, the company had to accommodate that request. And they have. So now, for whatever reason, they're saying they don't want to do it anymore. So why? Right? Why don't they want to do it anymore? There's one question. Is it business needs? Is it, you've been showing up late? Why don't they want to do it? And then the other question too, before we can really answer it and give you a full answer, is whether or not you still pick up your kid from work every day at 3 p.m., right? So if you had asked for this accommodation, well, let's say your kid was in 3rd grade, 4th grade, and he needed to get picked up from school every day. But now here we are 5 years later, and your kid's in high school and he takes the bus to and from school, and that's just your regular start time. Well, now that need for accommodation no longer exists, right? So they may actually be able to have you start coming in at the regular time. Now, with that being said, the accommodation piece adds a bit of a wrinkle, right? If that accommodation piece didn't exist and the company was just trying to change your hours, your work hours, it is always a case-by-case analysis. But sometimes when a company changes an employee's hours, does so unilaterally without asking, just does it, that can be considered a constructive dismissal. So a constructive dismissal at its core is defined as a substantial change to the terms of someone's employment unilaterally implemented by the employer. So in that case, if an employer unilaterally changes your work hours, taking you from a 6 to 2:30 p.m. and maybe has you working a 4 to midnight shift, right? Takes you from working days and makes you start working nights and overnights. Well, then that can be constructive dismissal. The operative word in any constructive dismissal case, whether it's that or it's a change in the rate of pay or it's a change in the commission structure, any of the million other variations, is that change substantial, right? I don't know when they're trying to get you to come in, Paul. So if they're trying to get you to come in from 6 to 7, change your start time from 6 a.m. to 7 a.m., that's probably not enough. Now, if they're trying to get you to come in at 10 a.m., now we're talking, you may have a case. So I think, in your case, it's, again, important that you speak with us. There are a lot of different wrinkles when it comes to the accommodation and it comes to the change of start times and what that change would mean. So reach out to us at employmentlawyer.ca. And the last part of your question is, could they fire me with cause and avoid giving me severance? So like I said earlier, they can do it, right? They can allege it. They can say they have cause. It doesn't mean they're right, and it doesn't mean it will hold up in court. If they try to allege cause and they fire you and don't pay you anything, then give us a call. Reach out to us, employmentlawyer.ca, email us, help@employmentlawyer.ca, and one of our lawyers will be able to pursue the company for a severance package. Assuming they didn't have cause, then you would be entitled to a regular severance package, and which could be as much as 24 to 30 months severance. So that's all my time for today. Thank you all for joining us. Again, my name is Teilen Celentano with employmentlawyer.ca. You can go to our website at employmentlawyer.ca or email us at help@employmentlawyer.ca. Thanks. I hope you all have a great long weekend. Bye-bye.